If Peter Obi will win at the tribunal, this will be the reason. Peter Obi, of the Labour Party presidential candidate, has filed his final written address, which is the last straw that will break the camel's back, because the Presidential Election Petition Tribunal has promised to deliver its judgment on September, so everyone is awaiting the judgment. Now, Obi has pointed out salient facts and has raised issues that has given him edge over INEC, President Bola Ahmed Tinubu, and the All Progressive Congress. One of the issues he raised is that prior to the 25th February presidential election, Kashim Shettima, who is now the Vice President of Nigeria, was previously nominated as the senatorial candidate of the All Progressive Congress for Borno Central Senatorial District, and it remained so till the 15th day of July 2022, when Shettima withdrew his said nomination as the senatorial candidate of the fourth respondent for Borno Central Senatorial District on the platform of the All Progressive Congress. While Shettima was standing nominated as the senatorial candidate of the All Progressive Congress, he was unlawfully nominated as the vice presidential candidate of the APC on the 14th of July 2022, thereby knowingly allowing himself to be nominated as both candidates in more than one constituency within the meaning and intendment of Section 35 of the Electoral Act, meaning that Senator Shettima Kashim, who is now the Vice President of Nigeria, was until 15th of July, when he declined nomination, withdrew his nomination on the 14th, which is a day before the 15th of July, was appointed as the vice presidential candidate of the All Progressive Congress. That is double nomination. Peter Obi also pointed out that the invalid nomination of Shettima Kashim of the All Progressive Congress nullified the election of President Bola Ahmed Tinubu as the presidential candidate of the All Progressive Congress within the meaning of the provisions of Section 142 of the 1999 Constitution of the Federal Republic of Nigeria as amended. Now, it is common knowledge that President Bola Ahmed Tinubu was a subject of an order for forfeiture made by the United States District Courts. Peter Obi raised that also in his final written address. He pointed out case number 93C4483, the order of forfeiture against President Bola Ahmed Tinubu of the sum of $460,000, which represents proceeds of narcotic trafficking and money laundering. He also explained in his final written address that the order for forfeiture against Bola Ahmed Tinubu was a fine within the meaning of Section 137 sub 1D of the 1999 Constitution, for which a person shall not be qualified for election to the office of the President if he is under a sentence of fine for any offense involving dishonest or fraud by whatever name called imposed on him by a court or tribunal. This is a real stronghold against INEC, Bola Ahmed Tinubu, and All Progressive Congress at large. He further explained, which is Peter Obi, in his final written address, that the virus of the statutory and constitutional disqualification of Senator Bola Ahmed Tinubu and Senator Shettima Kashim as candidates in the presidential election renders their purported return or declaration as the winners of the election invalid, null and void, and liable to be set aside by the courts. He said, pursuant to the mandatory provisions of the Electoral Act 2022 and the subsidiary legislations made thereunder, that Peter Obi, in his final written address, also pointed out that pursuant to the mandatory provisions of the Electoral Act 2022 and the subsidiary legislations made thereunder, to wit, regulations and guidelines for the conduct of the general elections and the Manual for Election Officials 2023, that INEC introduced the use of modern technology for the conduct of the 2023 general election. That by this, INEC represented and provided that it will use Bimodal Voter Accreditation System (BVAS) for the accreditation of voters in the polling units and the upload and transmission of the results of the election in real time on the day of the election and during the electoral proofs to the Independent National Electoral Commission Results Viewing Portal (IREV). That INEC vigorously campaigned that the use of technology in the electoral processes, including the upload and transmission of the results of the election in real time using the BVAS from the polling unit to the IREV, will ensure the integrity and the credibility of the election results in Nigeria. That contrary to the requirements of the law and in manifest disregard of its own representation, that the Independent National Electoral Commission abandoned and discarded the much expected upload and transmission of the results of the election in real time on the day of the election from the polling unit to the IREV, purporting same to be the results of the election in various polling units. That the blurred images and inaccessible documents which were purported to be the results of the election in the polling units, which is Form EC8As, the net results of the upload of the blurred images on the IREV was that the result of the election could neither be authenticated nor verified, and thus lacked credibility and transparency. Peter Obi, in his final written address, stated that President Bola Ahmed Tinubu and Senator Shettima Kashim contentions that the presiding officers of INEC duly uploaded polling unit results to the IREV flies in the face of the unchallenged documentary evidence of the blurred and unreadable copies of the purported Forms EC8A certified by INEC itself and given to the petitioners as a result of the election as per the Form EC8As in the polling units. Peter Obi also stated that they will show in their arguments that President Bola Ahmed Tinubu and Shettima Kashim, as per paragraph 76 of their reply to the petition, to the effect that their results being uploaded on the IREV are as contained in the respective INEC forms, and that all the results being uploaded emanated from polling units where elections were conducted is totally out of sync with the unchallenged documentary evidence before the Honorable Court, which is the Election Petition Court. That apart from the blatant refusal of INEC to comply with the mandatory requirements of the law, the certified copies of the results of the election given to the petitioners by the Independent National Electoral Commission manifestly show that the Form EC8As in several polling units were manipulated. Peter Obi also contended that though the presidential election was conducted at the same time, on the same day, at the same respective polling units with the National Assembly, Senate, House of Representatives election, the results of the National Assembly elections were successfully uploaded and transmitted from the Obi'S to the IREV portal. That strangely, only the results of the presidential election, equally held in the same polling units using the same infrastructures, could not, according to INEC, as required by law, be uploaded or transmitted from the polling units to the IREV. This is really strange. That the petitioners provided unchallenged evidence that the failure through neglect to upload and transmit the results of the presidential election held on the 25th of February 2023 was a violation of the collation process prescribed under the Electoral Act, and so substantially affected the results of the election. They raised in their final written address two issues for determination. One, that the petitioner, which is Peter Obi, and Labour Party adopt the issue for determination dated and filed on the 18th of May 2023, which is whether the second and third respondents, which is President Bola Ahmed Tinubu and Senator Shettima Kashim, are qualified to contest the presidential election by reason of the unchallenged facts and circumstances arising under Section 137 sub 1D of the 1999 Constitution, Section 35 of the Electoral Act 2022, and Section 134 sub 2B of the 1999 Constitution, and B, the issue of non-compliance with the provisions of the Electoral Act 2022 and the subsidiary legislations made thereunder, raised as A3, will be urged as a separate issue in the written address, and that the petitioner, which is Peter Obi and Labour Party, will show that the documentary evidence before the presidential election petition courts, read and examined together with the unchallenged experts and technical evidence of their witnesses, that the petitioners proved that the non-compliance of INEC with the relevant provisions of the Electoral Act 2022 and the subsidiary legislations made thereunder substantially affected the outcome of the questioned presidential election held on the 25th of February 2023. Now, with regards to what is the provisions of Section 137 sub 1D of the 1999 Constitution of the Federal Republic of Nigeria as amended, provides and outlines situations where a person can be disqualified as the President of Nigeria. Now, going down to sub D, it provides that a person can be disqualified if he is under a sentence of death imposed by any competent court of law or tribunal in Nigeria, or a sentence of imprisonment or fine for any offense involving dishonesty or fraud by whatsoever name called, or for any other offenses imposed by him by any court. Let's understand it, any court or tribunal, or substituted by a competent authority for any other sentence imposed on him by such a court or tribunal. Now, Peter Obi is hinging on that clause, any court, to say that since President Bola Ahmed Tinubu has been accused of an unchallenged order of forfeiture made against him by the United States District Court order of the Northern District of Illinois, Eastern Division, in case number 93C4483 over allegations of narcotic trafficking or financial transactions in violation of 18 U.S.C. SS 1956 and 1957. The decisions encapsulated in the order is tendered as Exhibit PA5. Peter Obi also pointed Section 142, which provides that in any election to which the foregoing provisions of this chapter relate, a candidate for an election to the office of the president shall not be deemed to be validly nominated unless he nominates another candidate as his associate from the same political party for his running for the office of the president, who is to occupy the office of the vice president, and that candidate shall be deemed to have been duly elected to the office of the vice president if the candidate for an election to the office of president who nominated him as such associate is duly elected as president in accordance with the provisions aforesaid. They submit that INEC, President Bola Ahmed Tinubu, Shettima, and the All Progressive Congress cannot take refuge over the Supreme Court decision they cited between the PDP and INEC, that the decision of the Apex Court is well decided for the facts and evidence before it, that the comment of the court on the date of the withdrawal of the third respondent, which is Shetim Kashim, is not a ratio of the case, that they submit that the date of July 6, 2022 on the letter of the withdrawal cannot be the effective date. It is not in dispute that Shetima Kashim signed INEC's interior election notice of withdrawal of candidates from EC11C on July 15, 2022. Until July 15, 2022, that Shetima still remained in the records of INEC as the senatorial candidate of the All Progressive Congress for Borno Central Senatorial District, that he could not validly accept nomination for the position of the vice presidential candidate of Bola Ahmed Tinubu before July 15, 2022. That the fact before the court is that it was on the July 14, 2022 that Shetima signed from EC11A notice of withdrawal of candidate pursuant to Section 33 of the Electoral Act 2022 with officials of the All Progressive Congress. Peter Obi also, in his final written address, pointed out the issue for controversy about conquering FCT and winning the two-thirds majority in each state.